Thanks everybody for joining. This is Venture Cafe St. Louis's series with Husch Blackwell. We have a monthly legal series with them to help startups and entrepreneurs navigate the business world and also consider what legal things they should be looking at, even while they're in the idea or early stages of their startup. So today we're excited to have with us Tara Ficken, who's with Husch Blackwell Cortex and it's an intellectual property attorney with the team. So, without further delay, I'm going to turn it over to Tara and to kick things off. So thanks again, Tara, for being here. Appreciate it.
Oh, it's my pleasure. Good afternoon, everybody. My name is Tara Ficken. Like Tyler said, I am an associate with Husch Blackwell in the St. Louis office. My practice focuses primarily on the domestic and international protection of trademark assets. I work with clients of all shapes and sizes, each with their own unique little challenges. That's what sort of makes trademark law so fun. We have a lot of ground to cover today. If you want to go to the next slide, Brittany, we're going to talk about quite a few things. First being sort of what is a trademark? Picking a strong trademark, using your trademarks appropriately, the trademark registration process and what benefits that might have for you, the concept of trademark clearance, what trademark infringement is and how to avoid it, and lastly, trademark enforcement and trademark enforcement tools that are available to you to make sure that your marks stay strong marks. Feel free to put questions in the chat. Brittany, my colleague, is going to be monitoring that, and I want to make sure that we're getting you the information that you actually need. So feel free to ask questions throughout. You don't need to wait until the end. So let's just jump straight in. What is a trademark? So Brittany? I get this question a lot, the difference between a trademark and a service mark. So a trademark is any word, name, symbol, slogan, logo, or any combination of those things that identifies your goods or services and distinguishes them from those of third parties or your competitors. So trademarks are more focused on the actual goods or physical products. A service mark is a trademark that deals with services as opposed to physical products, but they're essentially the same thing. The idea behind trademark law is a consumer protection mechanism. So how do I, as a consumer, when I'm going through the store and I see 50 brands of breakfast cereal, for example, how do I know which ones are the ones that I want? I really like General Mills breakfast cereals, and I know when I see that little logo on the box that those are the cereals that I like to buy. They denote a certain quality. So that's sort of the idea behind trademark law. Everyone knows what a trademark is. They just might not know that that's what it's called. So on the next slide, there are some examples of arguably famous trademarks. So you see the words Coca-Cola in their very distinctive red script. You see just the Nike swoosh on its own without the word Nike. You instinctively know that that swoosh denotes a Nike product. The McDonald's M with their slogan, I'm loving it. You know, I'm loving it means it's McDonald's product when it comes to food services. And on the next slide, we have some famous service mark examples. So, the Microsoft logo, Google, the Girl Scouts of America symbol when they're on those delicious cookies, which I have way too many boxes of downstairs. All of those things are used to denote the source of a particular good or a source of a particular product or service. So what does a trademark do? Like I said, first and primarily, it indicates the source of a goods or service and distinguishes it. So when I'm shopping in the mall, I say, oh, those are Lucky Brand jeans. I immediately recognize them by the Lucky Brand mark that's on the tag. They also guarantee the quality of the goods and services that are bearing that mark. So, oh, Lucky Brand jeans, I've heard those are really good quality jeans. And then finally, they create and maintain a demand for the product or service through advertising. So I see an advertisement for Lucky Brand jeans and I say, oh, look at that magazine ad. I have to go get the keys and get some Lucky Brand jeans. So again, it's more about distinguishing your goods or services and creating that demand because of the quality that your particular mark denotes. So why choose a strong trademark? Primarily, you want to choose a strong mark because it offers more protection. It better distinguishes you from your competitors in the marketplace. And strong trademarks are much easier to register and protect, which gives you more robust protection and more bang for your buck. You're also less likely to receive demand letters or other claims of infringement from third parties, which saves you time and money by choosing a strong mark right off the bat. So how do you go about doing that? I'm going to introduce you to the spectrum of distinctiveness, which is the funniest thing as a trademark lawyer. Basically, there are different kinds of trademarks, and each different type of mark, depending on how distinctive it is afforded a certain level of protection. So at the very top of the spectrum of distinctiveness are generic marks. And these are common terms for a genus of goods or services that are never protectable. So if you have a bottled water company and you want to call it spring water, that's going to be a very, very weak mark because spring water is a generic term. And to double onto that, arguably non-generic marks can become generic over time through misuse, which we'll talk about in a little bit. It's a term called genericide, which is one of my favorite terms. So that's sort of the far end where you're never going to get a registrable trademark. You're going to have a really hard time with a mark like this, protecting your mark from infringement by other people, enforcing it on third parties, or getting it registered with the trademark office. The next step up from that is descriptive marks. And descriptive marks are terms that describe a characteristic, feature, or nature of the product or service that you're using the mark on. So descriptive marks are generally not protectable, but they can be protectable through this concept of secondary meaning. So if you use a descriptive mark for long enough, build up enough goodwill, you advertise it, use it properly, over time you can actually acquire rights in that mark, but there's still pretty narrow rights that you're going to acquire. So an example of this would be American Airlines, for example. They are an American airline company. So originally, arguably generic, but descriptive. And over time, they've acquired rights in that mark through their proper use of the mark, marketing, and all that kind of stuff. Another example is pharmacy, which was an example for, I think it was cannabis products that they tried to get registered, the mark pharmacy. Obviously, it's a play on the spelling of a traditional pharmacy where you would think of receiving medicinal goods. So the Trademark Office, along with a myriad of issues, found that to be arguably descriptive. Related to descriptive marks, but still higher up on the totem pole, are suggestive marks. So suggestive marks are marks that require imagination to associate the mark with the product. So suggestive marks are inherently distinctive and registerable, but again, they might have a slightly limited scope of protection. An example of this would be Burger King for restaurant services. Obviously, they, burger and Burger King denotes the type of food that they sell in their restaurants. But when I think of Burger King, I don't immediately think of, I mean, now I do because they're Burger King, but at the time you didn't immediately think of a restaurant or, a restaurant services. Same thing with chicken of the sea for tuna. Obviously, it's a fish, if you think of that as chicken, very common. But it takes a step to go from chicken of the sea to canned tuna fish or packeted tuna fish. So those are examples of some suggestive marks. Suggestive marks are most of what I deal with. It's very hard to come up with sort of the next step of the toll, and we're going to talk about it in a second. But that line between descriptive and suggestive can sometimes be a little nebulous. At the very top of the totem pole, you have arbitrary and fanciful marks. These are the marks that are going to be the strongest for you. They're going to have the largest scope of protection, and they're going to be the easiest to protect. So as you're thinking about your branding strategy early on in your startup or your entrepreneurship, This is definitely something that I recommend thinking about in terms of naming your products and your services. So arbitrary marks are known terms that have no association or relation to the claimed goods or service. Again, these are immediately registerable. You don't have to show secondary meaning. You don't have to use it for a long period of time. An example would be Apple for computers. An apple, we all know what an apple is, but it has absolutely nothing to do with computers. No one's going to think it has anything to do with computers right off the bat. So very strong mark. Same with camel for tobacco products. There's no association between a camel and tobacco products. And Domino's for pizza. Again, there's a step between the two. And fanciful marks, which are going to be the very easiest to protect, are newly created terms that have no recognizable meaning. So Google was created to describe the Google search engine. Same with Xerox or Kodak. Those are all brand names. Those words didn't mean anything before the brand owners applied them to their products. As with all things, there are special trademark rules to keep in mind. Names are very difficult to protect. Surnames are almost never protectable, being last names. And the idea behind that is if multiple people have the same last name, it could be confusing for consumers to try to distinguish between, Ficken Computers and, Ficken Grocery Store. So typically they will not allow for a registration of a surname. Names of living individuals can potentially be protectable, but you have to have consent from the named living individual, and that consent has to be in writing and on file with the trademark office. You actually have to include a copy of it with your trademark application. And same with the deceased individuals. The one exception to that is presidents. You can never protect a deceased president's last name. It's a very specific rule, but that's why getting a trademark attorney involved is sometimes a good idea when you're coming up with some of these names, because you would never know that that was a rule until you got very deep in the trademark process and had spent a lot of time and money getting to that point. Geographical indicators are also difficult to protect. So if you wanted to protect something like St. Louis Computer, for example, you're gonna have a really hard time getting that protected because you can't keep other people from using the term St. Louis to describe goods and services that occur in St. Louis. And you also are gonna have a hard time on the descriptionist front for that mark as well. So I tend to advise staying away from geographical indicators as much as possible. And that goes hand in hand with the imagery of city, state, or federal flags. Those are not protectable in logos. So if you are wanting to use some variation of the American flag, for example, in your logo, you can do that, but you're not going to be able to get a trademark registration, and that mark is going to be a pretty weak mark for you to enforce against other people. Foreign words also have some special rules. You can certainly use them, and they can be protectable, but you have to provide an English translation with that to the trademark office when you file your application. And when you're clearing those kinds of marks, you have to think about both the English and the foreign translation. So if I file in Spanish, but there's somebody with that exact mark in English, the fact that I'm filing in Spanish is not going to be enough to overcome a likelihood of confusion claim from the trademark office. And it's not going to be enough to overcome an infringement claim if they decided to come after me. So that's something to consider as well. Disparaging and scandalous marks, I left an asterisk because that used to be a big no-no. And nowadays, it's not. There's been some Supreme Court activity in the last 2 years that has actually said that those marks are capable of trademark protection and the trademark office will accept it. The huge case at hand, the first one was dealing with the band, the Slants, and they tried to get a trademark registration and were denied on the basis that it was racially derogatory, and the trademark office wouldn't allow the registration. They ended up taking it to court and ended up drastically changing years of trademark law. So now you can get marks in that space. Again, there might be marketing and business reasons not to use those kinds of words, but it's available to you now. And finally, ornamental marks. That's something that I deal with all the time. If you have a mark that you're putting on the front of a t-shirt, like you want to put your business logo on the front of a t-shirt and sell the t-shirt, you can certainly do that. But the problem is the Trademark Office doesn't consider use in that fashion to be trademark use. It's not denoting a source. It's just a cool design that you put on the front of a t-shirt and you're selling to consumers. What you would need to do is also have that mark on the tag, like the hang tag coming off the shirt, or on the tag in the back of the nape of the neck. You could even have placement on the shirt, like if it's in a small logo on the right breastplate, kind of like they call it the polo placement, where you see the little polo guy on polo shirts. That could denote a source. But just putting it on a coffee mug, just putting it on a keychain, just putting it on the front of a shirt is not going to be enough at the Trademark Office to claim trademark protection. So if that's all you're planning on doing with your mark, that's fine. Go ahead and do that. There's nothing stopping you. But just know that if that's the only way you're using it, you're not going to be able to get a trademark registration for that particular mark. I see a question that says, aren't there a lot of companies named after Benjamin Franklin? How do they protect that name? We'll get into this in a couple of slides, but you can still use a mark and establish some sort of common law protection. The rules that I'm talking about here are on the federal level. And the federal level and federal registration has certain benefits that we'll talk about. You can certainly use it and build what's called common law rights, which are basically rights in the very specific areas where you've used your mark, geographic areas. Certain states might not have those same restrictions, or they're just using it improperly, which is also very, very common, with no one to really go after them and say that they can't. So it's not to say that you can't use a dead president's name, for example. It's just you're going to have a really hard time getting a federal registration and that robust of protection for a mark like that. So proper trademark use. As I just said, trademark protection actually is established through use. It doesn't actually come from registering that trademark with either the state or the federal government. So if you decide on a particular brand name for a product or service, you can file for a trademark application before you have actually started using that mark in commerce. And we'll again talk about that in a little bit. But your rights don't actually begin to accrue until you put out your product or start, selling your service that has that mark on it. Using your trademark properly is very, very important, because if you don't use it properly, you put those rights in jeopardy. So for example, you always want to make sure you use your mark as an adjective and not a noun. So a proper way to use it would be, I'll have a Coca-Cola soft drink, instead of I'll have a Coca-Cola. We all do it. I do it all the time. But the Coca-Cola company does not want you to do that, because that puts their mark at risk of genericide. You also want to try to use a generic term following the mark, again, so it's used more as an adjective and not as an actual noun. So that's why I said Coca-Cola soft drink instead of just a Coca-Cola. You also want to avoid using the mark in a plural form. So enjoy the taste of Coca-Cola soft drinks, not enjoy drinking Coca-Colas. Next slide, please. You also want to avoid using the mark as a verb. So I mentioned Xerox earlier. And I'm sure many people at one point in time have said, will you Xerox this? The Xerox company does not want you to do that. There's actually, Google was sued a couple of years ago now by a person that wanted to file some registrations with the word Google in them. Google opposed the registration, and this person's defense was, well, you haven't been using Google properly. People just say, I'm going to Google that. They don't say, I'm going to use the Google search engine. So your mark has become generic for search engine services. The Trademark Office actually did not buy that argument. They said, even though somebody might use it as a verb and say, I'm going to Google that, they mean they're going to go to the Google search engine and search that term on the Google platform. They're not saying, I'm going to Google that and go to Bing or some other search engine. So Google very narrowly escaped a genericide argument there. And I think it was a big wake-up call to a lot of companies to make sure that they're using their marks appropriately. Velcro is actually, I think we'll talk about this in a little bit, but Velcro is actually in the process of trying to battle that argument as well. And their legal department has released a few very funny, at least to me, online videos to consumers trying to get them to understand that Velcro is the brand name. It's not the actual product itself. Because they're sort of in a similar situation where people are starting to associate Velcro with just the product and not the brand of product. So that's a very, very big one. You also want to make sure that you use your mark consistently. So if you have a logo or design elements, a particular capitalization, you want to make sure that you use it in that form very consistently. If you start to use it in many different kinds of forms where there's no consistency for the consumer, you open yourself up to an argument that your mark is really no longer serving that source identifying function anymore. So if you pick a stylization, stick with it. It's okay to decide to change it, but change it consistently everywhere and keep that use consistent. And finally, as we just talked about, don't use it in an ornamental fashion. It's fine to put your mark on merchandise and use it that way. That's perfectly acceptable. But just make sure that you're also using it in a source identifying fashion so that you can get your trademark rights if you're seeking registration and then maintain those rights as you continue to use your mark. So next we're going to talk about genericide and descripticide, which just the word genericide is one of my favorite words just because it's so fun. But there's this great quote that says, "The path to marketing oblivion is littered with the good intentions of zealous advertisers and marketers who made their brands household words and then dictionary terms." So I have 3 images there. These 3 things all used to be registered trademarks. The word aspirin, thermos, and yo-yo. Those were all registered trademarks at one point, and over the course of time, they became generic to describe just the product that, that they were used on. Currently, as I said, there are a few companies that are fighting genericide terms, Xerox being one of them. I'm going to go to the next slide, Brittany. Xerox, Velcro, and Google are all, like I said, fighting that, that great thing that you as marketers want to happen where your brand becomes a household name. But if that happens, that can be risky. So it's very important from a marketing and business strategy standpoint to make sure that the marketing departments that you're working with, the advertising companies are all using your marks properly so that you can maintain those protections as your brand continues to grow in prominence. So intellectual property and social media. Social media is not new anymore, but it is still ubiquitous. It's still a huge way for companies to try to market, particularly young startup companies, entrepreneurships that are using these platforms to really push their products and their services and try to get a foothold in the market. It's really important when you are posting on social media to make sure that you're using your marks properly in all your posts and in your advertisements. Make sure your marketing departments or your marketing people are working with your legal counsel, working with people who sort of understand those nuances to make sure that anything that you're putting out there isn't going to put the rights of your mark at risk. I very routinely look at social media posts, look at advertisements that my companies are wanting to put out there just to make sure that they're, you know, using the right logo, that they are calling attention to it, and it's not just mentioned in the body of text in a social media post and not actually being used as a brand name. All those kinds of things are really important. Just from a general perspective, think before you post. This is most important when you're thinking about posting something that has to do with a competitor. If you're wanting to make some statements about how your product is so much better than a competitor's product, or if you're using someone else's trademarks or images, music, things like that. It's very important to stop before you hit that submit button and make sure that you've done your due diligence and that you're not getting yourself into potential hot water. If there are images, music, or videos that are being used in the post, you have to make sure that you've conducted a clearance of rights search. Because if you don't do that, not only could you potentially open yourself to trademark if you're using someone's trademark in your own advertising, you could be opening yourself up to infringement in that way, but there's also potential copyright infringement, which is a whole separate beast for a whole separate presentation. And copyright is no joke. I had a client that was a university, and they had a journalism program that posted online 10 years ago, I think it was, an article about a movie on Netflix and used a picture that they'd gotten off of Google of the actress, the lead actress in the film. And 10 years later, we got a nastygram from the photographer of that picture, and he wanted $15,000 or he was going to file a copyright infringement suit. And unfortunately, we had some arguments. They weren't the world's greatest arguments, but defending against a copyright litigation or any litigation is incredibly expensive. And they ended up settling that for $12,000 for a post that was made 10 years prior by a journalism student. It can be very serious and it can be very costly. One of the things that you can do to protect yourself against that is when you're looking online, if you want to find some images, Google actually has a way through the Google image search to filter it to only be copyright-free images. So you can do that way. And I would just really impress on anyone you're working with on the marketing side, whether it's an internal person or an external person, to just double check, make sure that you have the rights to use anything that you're wanting to use in a post. And this can be also said for pitch materials as well. So if you're in the process of pitching and you want to use certain music or an online video or something like that, you need to make sure that either it's free of rights or that you've reached out to the owner of those rights to come to some sort of arrangement where you can license them and use them properly. You also want to be careful about using materials from sharing sites like Pinterest. It's arguable that it could be fair use for your individual use, but if you're using it in a commercial context, that fair use claim can shift very drastically. And fair use it's easy enough to say, oh, my use is fair use, but it's actually a very complicated analysis and there's a lot that goes into it. So again, if you're wanting to use those kinds of materials, I highly recommend working with either your in-house or external counsel and make sure that you have, you've done your due diligence and that you're comfortable using those materials and making that risk assessment. And finally, sorry, Brittany, go back. There was one more point. You also want to check the terms of use for any online source that you seek to use, text, image, video, music, etc. Even if it's from like a free site, because sometimes the terms of use are okay for individual use, but not for commercial use, and there is a difference. So if you're using it in a business context, you always want to make sure that even if it's from a free site, you've done your due diligence. Let's see, we have a question. I think I have a couple of questions. Let's just take a second. Let's see. Julie, we're going to talk in just a minute about the difference between the circle R versus the TM and the SM symbol, but basically it has to do with the status of that mark and whether it's registered or not, but we have a whole slide dedicated to that. Rachita says that she's looking at trademarking her business name, and on the website it says it's available. Is it worth trademarking? given that both are technically available or does prevent infringement liability. So I unfortunately cannot give any specific advice as to your trademarks or your particular situation, but we're going to talk about trademark clearance in just a little bit, and hopefully that will sort of give you some guidance as to this question. If you have more specific questions, we can certainly talk separately. And then this person says, if I'm trademarked in a certain area of products but someone has trademarked the same name in t-shirts, does that mean I can't sell t-shirts representing my name? That's a very good question. That sort of goes back to this idea of ornamental use. So a lot of it would have to do with how are they using their mark. If they are actually using their mark on the label or something like that to actually denote the source of a t-shirt, you might have some risk there. If, however, you are just wanting to use your logo on a t-shirt as a merchandising opportunity, even if they were to come after you, the argument would be that you're not using your mark as a trademark. It's ornamental use. It's just merchandise for your mark that you've established protection in for your core business. So I think your risk there would be fairly low. But again, that's something that if you have very specific questions about, or if that's a very particular concern, we can talk about separately, Chris. And is the presentation available via email? It is being recorded. And my understanding is that if you've RSVP'd for this session, you'll get an email afterwards with a link to the recording. Okay, so let's jump into trademark clearance. How do I make sure the mark that I want is available? The easiest thing to do is to search that mark. So before you adopt, you need to make sure that either you or an attorney like me or an attorney that you're working with has sort of done a little searching on that mark to make sure that no one out there is using it. Failing to perform an adequate search can result in potential liability. So I cannot emphasize enough how important it is to do just a little bit of due diligence ahead of time to save yourself a lot of headache down the road. Your search options, your best option would be to call a trademark attorney like myself. We live, breathe, eat, sleep trademarks. We have access to databases that are not public. So Husch Blackwell pays for certain services that allow me to very easily search federal and state registered trademarks to make sure that you're not running into hot water. If that is outside of your budget or not something that you're interested in, you can do some searching yourself. The United States Patent and Trademark Office has a search function. It's called TESS, the Trademark Electronic Search System. It's public. Anyone can log on to uspto.gov and go to TESS and search their mark. It's not the world's most intuitive searching system. So for example, if I type in the word Mid-American, it's only going to pull up marks that have Mid-American in the exact spelling and spacing that I've put in. So for instance, it would make a difference if I had no space between Mid and American and a space between Mid and American. It also isn't going to catch things that are slightly different, so slight misspellings or, searching design marks is next to impossible. So it certainly is an option for you. Just know that it's going to be a very, very basic search, and there might be other things out there that search won't capture that could be cited against you. So it definitely is not a true substitute for the type of search that I would be able to do. I also recommend using Google at a minimum. So just Google, see what's out there. If, on the first page, there's someone with your exact mark doing exactly what you do, that's obviously a really big problem. Again, not everything that you find on Google is going to be registered. So that's the other caveat there. And just because they're not registered doesn't mean that they don't have rights and that they couldn't potentially come after you. But, between the two, you should be able to get a pretty good sense of what is out there. But again, it's not guaranteed. So if you have any questions on clearance searching, feel free to put them in the chat and we can chat about it. But we'll move on to investigations. So what if you do that search and you find that someone might be using the mark, but you can't really tell? You can always do a more thorough trademark investigation. These investigations, we usually work with third-party investigators to determine, one, whether the mark is in use at all. Sometimes you'll find a website that's from 10 years ago and you have absolutely no idea if they're still in business, if they still do what they're saying that they do on the website because it hasn't been updated. There can be a lot of questions. So they can determine whether the mark's in use, who is using the mark, if it's this company, or if it's maybe a subsidiary, or they sold the assets 10 years ago and now it's a whole separate company. They can tell you how long the mark has been in use. So if they've been in use for 1 year versus if they've been using it for 20 years, that would all make a difference in sort of the analysis of whether this mark is worth pursuing or not. I can also tell you how the mark is being used. So sometimes maybe how a mark has been applied for, if somebody's filed an application with the trademark office, is not how they're actually using the mark. That can be very important to know. So if they're not using it on what they say they're using it on, for example, that's very important. Or if they are using it on other things that maybe aren't covered in an existing registration or an existing application that you found on the PTO website, for example. All of that would be very interesting to know and sort of impact that analysis that you're doing. These investigations, at least for us, I'm not sure if we have negotiated specific rates with some of these investigators or if that's just their cost, but they're not super expensive. I think our main one that we use is around $250 for the investigation and the investigation report. So if it's a mark that has a lot of meaning to your business and you really want to make sure that it's available, that's something that you might consider. So trademark registration. Registration, first of all, is not required. So like I said earlier, it's based on use. Begin using your mark when you're ready to use it and you'll start acquiring rights. You do not have to wait for a trademark registration to start using that mark on product. With the caveat being, you should make sure that you've searched it and cleared it before you started using it. There's this idea of first to use versus first to file. If anyone has dealt with a patent attorney or is an engineer and filed for a patent, that becomes very, very important in patent law. In trademark law, it's important. It's not quite as important. So the first to use is going to have very limited rights in those geographic areas where they used first. Versus the first person to file can still get a registration, even if somebody has been using it on an unregistered basis. And it would then be on the prior user to come forward and say, actually, I acquired rights in this mark first, and you sort of get into what's called a priority battle. Sometimes what happens, most of the times those settle because it's very expensive to have those kinds of battles and neither side really wants to get into that kind of fight. But sometimes what happens is you can have what's called concurrent use. And that means that you basically split up the country geographically. So, I used first in the, Northeast and Southwest, and that's where my rights are. And, the other person takes the rest of the country. Those are formal agreements that these companies come to that, again, are filed with the trademark office. So, both have their rights. They're just sort of limited. When should you register? Ideally, you would register when you are considering using the mark. That's called an intent to use application. So basically you tell the trademark office, this is the mark that I'm planning on using. Here's how I'm planning on using it and what I'm planning on using it on. It goes through the entire registration process up until the point of actually issuing a registration certificate. Once it's to that point, it's actually sort of put on hold. So you have 6 months from that point to start using the mark, or you can file up to 5 extensions. So I tell clients, if you're pretty set on using a mark, but you're still sort of working on bringing those products or services to market, you're still doing market research, go ahead and file your application. Get your application in line, because the sooner you get on file, the sooner you're going to be able to prevent other people from sneaking in ahead of you and getting that mark, even if they start using before you start using. So in that case, the first to file is very important because it saves your place in the queue. And intent to use applications, your constructive first use date, or the date that the trademark office says that your rights start, is actually the day that you file, not the day that you start using. So this can be really important when you're sort of in that those beginning stages of your business and figuring out sort of what your product and service is going to be called, and you do those clearance searches. It's a little more expensive. There's some additional filings that you have to do down the road, but the benefit that you get from going ahead and getting that placeholder in the trademark system can be very invaluable. Alternatively, if you've already started using your mark, you can file as a use-based application. You basically have to provide the trademark office with the mark, what you're using it on for the goods and services, the date that you started using it in commerce, and provide some examples of how you're using it on the goods and services in your application to the trademark office. That process can take anywhere from 6 months to a year. It's not a quick process, which is why I tell people to go ahead and file as soon as you're sure that that's the mark that you want, just to get the ball rolling. 6 months is very idealistic. That's pretty much if a mark sails through with 0 questions from the trademark office and 0 issues with the application, you can get it in 6 months. More typically, you're looking at least a year. So keep that in mind when you're coming up with your strategy. Understand that it's not going to be an immediate process, so the sooner you start, the better. And you want to make sure that you don't let waiting for the registration to issue impact your plans for using the mark. Just proceed as business as usual. The trademark, you know, it's important in terms of, you know, the benefits of registration, but it shouldn't delay your plans for actually launching a mark in commerce. So don't think the cart has to come before the horse here. Your use should come at its own pace, and the registration will follow, whether you file it intent to use or after the fact. And then finally, you do not need an attorney to file a trademark application. Those are actually, I mean, you do if you're a foreign company, but you have to, sorry, Brittany, can you go back a slide, please? It's always a good idea to work with someone that understands the process. I've prosecuted hundreds of applications with the trademark office. I can usually spot pretty quickly if I think there's going to be an issue with a particular mark. So that's one reason to use an attorney. I also would recommend being careful with companies like LegalZoom. They can be great and they have their place and their purpose, but you work with an attorney at LegalZoom, but they're not going to review your mark and tell you its likelihood of success. You're just going to say, I want to file this mark, and they'll say, okay, and they'll hit the file button for you without telling you, by the way, this mark has a very low likelihood of actually getting through to registration. So I've dealt with a lot of clients that come to me after using LegalZoom trying to fix an issue that came up in prosecution. So you don't need an attorney to register, but it's a good idea to at least consult with one. Are photos offered through PowerPoint templates considered copyright free? So that's a very interesting question. My short answer is don't trust it. I think it used to be there was like generic clip art. Nowadays, I'm pretty sure that it interfaces. It's basically like performing a Google search. I know when I was putting this presentation together, I found some images that I really liked. And when I looked at them more closely, there was a link that took me to where they got the image online. And I didn't 100% trust that those were copyright-free images. So I always say trust but verify. It takes, you know, a couple of minutes to just sort of follow the breadcrumbs and see where it takes you. And if you find yourself getting in a place that you're just not sure, I'm a pretty fairly conservative person on the risk spectrum. So for me, I just look for a different image that I'm confident is available to me. The benefits of federal registration. So why should you register? You get nationwide rights, so you're not limited to that one geographic area where you started using. A federal application actually is considered constructive use for the entire country. Even if I've never sold product in California, but I have a federal registration, I'm protected in California. It also gives you nationwide priority. So again, going back to that idea of, you know, who used first versus who filed first. If you have a registration, you're considered to have priority over any other use in the country from that applicable date, whether it was the date you filed for intent to use or the date that you started using in commerce in your application. It also has a presumption of validity. So if you get into a litigation battle, sometimes if it's on common law type rights, there's a question of whether your trademark is even a valid trademark. If you have a federal registration, that's a non-issue. It's just considered to be a valid trademark. That's a presumption from the very beginning, and you can move on from that, that point. It also counts as constructive notice to third parties. So using the proper symbol, which we're going to talk about in just a minute, is sort of notice to third parties that either you have a registration if you're using the registration symbol, or that you're claiming common law rights by using the TM or the SM symbol. So all of that comes from being registered with the trademark office. Also, if your company has, you know, sites internationally, you can file foreign priority filings based on your US registration. So you can actually file in China after you've gotten your US registration, and the date of your Chinese application will be considered to be the date you filed your US application. So that can be very effective for international strategy in terms of protection that way. You also, if you use your mark properly for a period of 5 continuous years after your registration, you get what's called incontestability status. And that drastically reduces the ways that people can challenge your mark, either based on likelihood of confusion, you're not using it. Non-use is always a grounds for cancellation of a mark, but that incontestability status can be really invaluable. And finally, it gives you the right to file your trademark with US Customs. So if you are, you know, importing product from a foreign country, you can actually file your mark with Customs. You have to have a federal registration, and Customs will actually help you in enforcing your rights at the border and making sure that infringing products don't come into the country. So again, depending on what type of business it is that you're running, that can be very crucial. So how do you register? It's an online application process all through the USPTO website. That's uspto.gov. Everything is electronic, from the actual filing and signing of the application to correspondence with the trademark office, to actually getting your registration certificate electronically, and then they mail you a physical hard copy. So it's really easy and simple. Like I said, the process can take upwards year, 18 months. Things have slowed down a little bit with COVID. I've been noticing a little bit more of a delay with the trademark office, but nothing, you know, crazy. The filing fee is based on the number of classes that you claim in the application. As of January 1st, they just increased the filing fees. It went from $275 to $350 per class, which is unfortunate, but there's nothing that trademark lawyers can do about it. So for instance, if I am filing in both clothing and retail store services, clothing is in class 25, retail store services are in 35. So 2 classes, $700 in filing fees. The timeline, once you file your application, it's assigned to an examining attorney who's a person that works with the trademark office, usually within 3 to 4 months. They review the application, and if they have any issues with it, which 9 times out of 10 they do, even if they're very, very small issues, they will issue what's called an office action, or they'll, if it's a small issue, they might reach out via phone or email to resolve it. But they'll let you know sort of, here's the issues we found with your application. Either, we found someone else that's using it, that's the worst. We think the mark is descriptive, even if we don't think it is. All of those kinds of things will come in this office action. You have roughly 6 months to respond to that office action, either making your arguments. Sometimes it's as simple as they don't like your goods description and they want to make a few tweaks to it. Very, very simple. So it could take 5 minutes. It could take a couple hours of research and drafting time to prepare a response. Once all of those issues are resolved with the application, then it proceeds to publication. So it's published for a period of 30 days. This is to give third parties who think that they have a senior claim to the mark an opportunity to come forward and formally oppose the registration of that mark. Opposition actions are not common. I think I've seen 3 or 4 in my years of practice. But they do happen from time to time. Sometimes they can be settled very quickly and some sort of settlement agreement or licensing arrangement can be arranged. If it can't be resolved quickly, then you do have to go through a separate proceeding with the Trademark Trial and Appeal Board. It's basically an adversarial proceeding, very similar to litigation, just with an administrative body. So it's not common, but if it were to happen, it's a whole separate process. Once the mark is allowed, if it's an intent to use application, or if it's accepted, if it's a use-based application, then eventually you receive a registration certificate. Sometimes it can take a month or 2 for that registration certificate to issue, but that's when you officially have your rights. Okay, so the registration symbol. The R in the circle is the actual registration symbol, and that can only be used if you have a federal registration with the United States Patent and Trademark Office. If you don't have a federal registration, you can still use the TM or the SM symbol. That is used to denote that you are claiming rights through use in commerce, and it's not a registered mark. It certainly can be a valuable tool while you're in the registration process. For example, you can put the TM symbol until you get your R symbol, or if you're just relying on common law rights, putting that on there at least is considered notice to other parties that you're claiming those rights. So, but making sure that you're using the right symbol is very important. So if you do not have a federal trademark registration, even if you have a state trademark registration, for example, but you don't have a federal, you cannot use that R in a circle. That's very, very important. It can be, actionable. So don't use that R symbol unless you're actually registered. So trademark infringement results from the unauthorized use of a mark that is likely to cause consumer confusion. So it can result in injunctions, monetary damages, awards of attorney's fees. It can be very serious. And there are a lot of factors to be considered when you're reviewing sort of whether what you want to do might constitute infringement or not. A lot of it comes down to how similar is your mark versus the mark of the third party. How similar is what you're doing to them? Are you in the same type of market? Are you advertising to the same customers? Are they business to consumer and you're business to business? Do your marks appear in the same place? There's a lot of factors. So if you come across something that you're concerned might be trademark infringement, or if somebody else is using your mark in a way that you're just not sure, I do recommend reaching out to an attorney and sort of get an analysis of the risk and sort of what you might be opening yourself up to, or conversely, if it's worth the expense of initiating some sort of enforcement action against that third party. So examples of infringement can be passing off. So if I have a product that is, not affiliated with a particular brand, but I slap that brand's logo on it and sort of pass that good off as belonging to that brand, even though it's not, that's obvious infringement. Use of somebody's brand in meta tags online, it can be considered infringement. That's a really specific analysis that's sort of outside the scope of this presentation, but just something to consider when you're online advertising. Social media accounts, uses of brand names as social media handles could be infringement. Counterfeit products, obviously, unauthorized sellers online of your product. again, could be infringement, and misleading product packaging. All of those are examples of actionable infringement. One of the ways, this actually happened to a client of mine, they became aware of somebody that was pretending to be them on Google Business. So if someone typed in their company name on Google, that box on the right-hand side would pop up and it was not them. So we had to work with Google to get that taken down and try to figure out who was behind that. So that's just an example of something that you should consider and keep an eye out for in your business. And later we'll talk about it a little bit more if we get there. We're running out of time, but you know, claiming your Google business pages and things like that can be an important tool and strategy for you. AdWords takedown. So if you become aware of somebody in online advertising that you think is using your mark inappropriately, you do have options for getting that advertisement taken down. You can submit a complaint through Google or whatever search engine. I've submitted them on behalf of clients several times. It is a fairly easy process. It's much easier to do when you have a trademark registration. So usually they ask for a copy of your registration certificate. But that is an option, especially with online advertising being all the rage nowadays. Someone else is using my brand as a social media handle. And my response is usually, wow, that's really unfortunate. You really need to consider social media accounts when you're deciding on your brand names and lock them down early in the process. It can be very difficult to get those social media handles after the fact, particularly if it's not a company handle. If it's an individual that just happens to have your handle and they're not really using it for business purposes, the platforms are very hesitant to take those handles away from individuals. So register early, monitor them, and make sure that you have them locked down early, because that can be a real problem. So the last couple of slides, and I hope we get to all of them, we're just going to talk about some free tools that you have. Well, some of them are free, but tools at your disposal as business owners that you can use to monitor the use of your marks online and can help you with your enforcement strategy. So Google Business Verification is the first one. Like I was talking about before, if somebody types in your brand name in Google and that little box pops up, you want to make sure that that's you. So that locks that down. Amazon has a brand registry. So if you're selling products on Amazon, you can actually register your trademarks with Amazon. And it provides some tools through the platform to help you monitor other people's use of your marks on that platform and make sure that you know, you're on top of the real problem of third parties selling counterfeit or misleading products online. Social media sites all have their own trademark and intellectual policies. So if you do find activity on social media that you think is infringing, you can submit a report. I'm submitting some through Instagram for a client right now, actually, where somebody has created some Instagram handles and has used images from their websites. We have both trademark and copyright claims there. But each site has its own little nuances. So you want to make sure that you look through them. There are also online monitoring options for you. Those are usually paid, but there are companies that specialize in that, and they monitor the marketplace for you and make sure that no one is doing anything untoward. And finally, cease and desist letters, always effective. My 5-second recap, because we're out of time, is in our online world, those can very easily become a marketing tool, both for or against you. So the tone of your letter is very important, making sure that you do due diligence before you send the letter, that you actually have the rights that you're claiming. And, you know, think about whether you're comfortable with that letter being posted online, because it just might be. And again, it can be a marketing strategy, and Netflix had one that was really great based on Stranger Things that's in the slides. If you get a copy of the slides, if you don't, feel free to send me an email and I'll be happy to send you a copy. But it can just as easily also go the other way. So if you send a really nasty cease and desist letter, it could be posted online as a, you know, big bad company going after a small mom and pop shop and become kind of a PR nightmare. So consider that PR and marketing angle when you're deciding how and where to enforce your marks.